A 9-0 decision just dropped from the Supreme Court. Not 5-4, not 6-3, 9 justices, 0 dissent. And here is what nobody in the mainstream media is telling you. When all 9 justices agree, from Justice Thomas to Justice Sotomayor, the political alarm systems go quiet. Nobody screams, nobody trends on social media. The cable news chyrons move on to something louder, and that silence is exactly how the most dangerous shifts in American constitutional law slip through without anyone noticing. Because a unanimous decision doesn't look like a threat. It looks boring, it looks settled, it looks like the law was obvious and nothing really changed. That conventional wisdom is dead wrong. And over the next several minutes, I am going to show you exactly why, because what the Supreme Court has done across 3 unanimous and near-unanimous decisions from 2022 to 2026 represents the most significant restructuring of your Fourth and Fifth Amendment rights in decades. These are not isolated rulings. They form a pattern, and that pattern has been quietly rewriting the rules that govern how every American interacts with police. Let me be specific. Let me give you real cases, real names, and real consequences. Because you deserve more than vague warnings. You deserve to understand exactly what changed, exactly when it changed, and exactly what you need to do about it right now. We start in May 2025 with a case called Barnes versus Felix. Ashtian Barnes was a young man in Texas. He was pulled over for a routine traffic stop, a toll road violation, the kind of stop that happens 1 million times a day across this country. The encounter escalated. The officer fired his weapon. Ashtian Barnes died. His mother, Janice Barnes, spent years fighting for accountability. The case eventually reached the Supreme Court. And the legal question at the center of it was not simply whether the shooting was justified. The question was this: when courts evaluate whether a police officer used excessive force, how much of the story are they allowed to see? Because lower courts, particularly in the Fifth Circuit, had been operating under something called the moment of the threat doctrine. Under this rule, judges were only allowed to examine the precise split second when the officer pulled the trigger. Nothing before that moment counted. Not what led to the stop, not how the encounter was handled, not whether the officer's own actions created the danger he then claimed to be responding to. Think about how radical that is. If an officer stops you for a broken taillight, escalates the situation needlessly, and manufactures the very crisis he then uses to justify deadly force, none of that counts. The only question is whether in the instant the gun fired, a reasonable officer would have felt threatened. That is a legal framework that rewards escalation and punishes accountability. And the Supreme Court unanimously said it was wrong. Justice Elena Kagan wrote the opinion, and her language was clear. Courts must consider the totality of the circumstances, and that inquiry has no time limit. Not just the moment of the shooting, the whole story. That sounds like a major win for civil rights, and at first glance, it is. But here is where you need to slow down and read the fine print. Justice Kavanaugh wrote a concurring opinion joined by Justices Thomas, Alito, and Barrett. He agreed with the outcome, but his reasoning pointed in a completely different direction, emphasizing the dangers officers face and making clear that this ruling was not designed to make it easier to hold police accountable. It was about getting the standard technically correct, and the standard they landed on, totality of the circumstances, is one of the most flexible phrases in all of American law. It can mean whatever a judge wants it to mean. Prosecutors will argue that certain facts are too remote in time to matter. Defense attorneys will fight to include everything. Police departments will train officers on how to create favorable records before a confrontation occurs. The litigation will grind on for years with no guarantee of meaningful accountability. Barnes versus Felix rejected a bad doctrine. It did not replace it with a strong one. It replaced it with a shapeless one. But that decision did not happen in isolation. To understand what is really going on, you have to go back 3 years earlier to 2022 and a case called Vega versus Tekoh. Most Americans know what Miranda rights are. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. These warnings come from a 1966 Supreme Court decision. They are woven into the fabric of American criminal procedure. And most Americans assume reasonably that if a police officer violates those rights, if they simply choose not to read them, there must be real consequences. Vega versus Tekoh said no. A 6-3 majority with Justice Alito writing for the court held that Miranda warnings are not themselves a constitutional right. They are what lawyers call prophylactic rules, rules designed to protect a constitutional right, but not the right itself. The Fifth Amendment prohibits compelled self-incrimination. Miranda just creates a presumption that a statement is compelled if you weren't warned first. But because that presumption can be overcome, failing to give warnings is not automatically a constitutional violation. Do you see the sleight of hand? The court created Miranda in 1966 as a constitutional safeguard. In 2000, the Supreme Court held in Dickerson versus United States that Congress couldn't legislatively overrule Miranda, which is only possible if Miranda has constitutional force. But in Vega, the majority moved past that precedent entirely. And the result is this. If an officer deliberately skips your Miranda warnings, your only remedy is that your statement might be excluded from trial. You cannot sue the officer. You cannot seek damages. You cannot hold anyone personally accountable. Justice Kagan dissented, joined by Justices Breyer and Sotomayor. She warned that the ruling turns a core constitutional right into a mere rule of evidence, enforceable only at trial and only if the defendant can afford to litigate it. That last part is crucial. Most people cannot afford to litigate anything. Most cases never go to trial. Plea deals happen in the shadow of these rules. And in that shadow, the rules barely exist at all. Now pause and connect what you know so far. Barnes says courts must evaluate excessive force under a flexible, shapeless totality standard. Vega says police can skip Miranda warnings with no personal consequence whatsoever. The deterrent that once existed, the threat of a civil lawsuit, is gone. But the pattern doesn't stop there, because in February 2026, the Supreme Court handed down a third decision. Unanimous again, 9-0 again, almost no media coverage. And in combination with Vega, it effectively rewrites the Fifth Amendment's protection against self-incrimination for millions of Americans. The case is called Case versus Montana. And the facts matter, so stay with me. Michael Case was arrested in Billings, Montana on suspicion of drug possession. The arresting officer read him his Miranda rights. Mr. Case said he understood them. When the officer asked if he wanted to talk, Mr. Case said no. He invoked his right to remain silent, clearly, unequivocally. The officer stopped questioning. Correct procedure so far. 2 hours later, a different officer entered the interrogation room. He did not reread Miranda warnings. He did not reference the earlier invocation. He just started a casual conversation. How's your day going? You look tired. You seem like a decent guy. After 20 minutes of friendly small talk, the second officer said, Look, I'm just trying to understand what happened. Can you tell me your side? Mr. Case talked. He didn't re-invoke his silence. He didn't ask for a lawyer. He answered because the second officer had deliberately created an environment where silence felt awkward, where manufactured rapport had softened the formal legal moment, where the boundaries had quietly dissolved through friendly conversation. The prosecution used those statements to convict him. His lawyers argued that under established precedent going back to Michigan versus Mosley in 1975 and Edwards versus Arizona in 1981, once a suspect clearly invokes the right to remain silent, all questioning must stop. Not for 1 hour, not for one officer, but completely, unless the suspect initiates further communication on their own. The Supreme Court unanimously disagreed. Justice Amy Coney Barrett wrote the opinion. Her holding, police may attempt to re-engage a suspect after a significant break in time, and the suspect must actively re-invoke their silence if they want questioning to stop again. On its face, that sounds reasonable. If you said you didn't want to talk but later changed your mind, why shouldn't police be allowed to listen? But here is what that reasoning ignores entirely. A suspect in custody is not a free person making a free choice. The officers control the environment. They control access to food, water, bathroom breaks, phone calls, and lawyer visits. They control who enters the room and what atmosphere surrounds the conversation. When you are alone in a room for hours with no one but police to talk to, and a friendly stranger sits down and asks about your family, voluntary becomes a very slippery word. Justice Sotomayor wrote a concurrence in Case that reads more like a dissent. She agreed with the outcome because she felt bound by precedent, but she warned that lower courts must take the totality of the circumstances seriously when evaluating whether a suspect's later statements were truly voluntary. Notice that phrase again. Totality of the circumstances. The same phrase from Barnes versus Felix. Maximum judicial discretion, minimum guaranteed protection. Now let me show you how all three decisions work together in your actual life. In a scenario that would have raised serious legal problems 2 years ago, but is completely permissible today. You are pulled over for a minor traffic violation. The officer asks you questions without reading Miranda warnings. You are placed under arrest. At the station, 2 hours pass. An officer enters and asks if you want to talk. You say, I want to remain silent. The officer nods and leaves. An hour later, a different officer enters, friendly, relaxed. He asks how you're doing, whether you want coffee, where you grew up. 20 minutes of small talk. Then, look, I'm not here to trick you. I just want to hear your side. If you speak, those statements are almost certainly admissible. You didn't re-invoke your silence after the second officer began talking. The first officer honored your invocation by leaving. Courts have held that 1 to 2 hours qualifies as a significant break under Case. The friendly conversation was not formal interrogation, and when the second officer finally asked a substantive question, you chose to answer. The missing Miranda warnings? Under Vega, not a constitutional violation. You cannot sue. Your only option is convincing a judge that your statements were involuntary under the Due Process Clause, a far harder standard than a simple Miranda violation. This is not a hypothetical. This is the law of the land right now. Justice Kagan saw all of it coming. In her Vega dissent, she wrote that stripping Miranda of its enforcement mechanism turns a constitutional right into a mere rule of evidence, and that is precisely what has happened across all three of these decisions. The rights themselves haven't been abolished. The text of the Fourth and Fifth Amendments still exists, but the remedies that made those rights real, damages lawsuits, automatic suppression, clear invocation rules, have been quietly dismantled through unanimous decisions that received a fraction of the attention given to louder, more politically legible cases. The framers did not put these protections in the Bill of Rights because they trusted government officials. They put them there because they didn't. They knew that power concentrates. They knew that officials cut corners. They knew that the only real check on authority is a citizenry with enforceable rights and the knowledge to use them. So let's talk about what you still have. Because this is not hopeless, and understanding your remaining protections is the only way to actually use them. You still have the right to remain silent. The Fifth Amendment has not been repealed. If you say nothing from the moment of arrest until a lawyer is present, the government cannot force words from your mouth. The changes in Vega and Case affect procedures and remedies, not the underlying right. Silence, maintained completely and consistently, is still your most powerful tool. You still have the right to counsel, and right now it is significantly stronger in practice than the right to silence. The right to counsel is governed by Edwards versus Arizona, which Case versus Montana did not touch. Once you ask for a lawyer, all interrogation must stop. Police cannot reinitiate, they cannot send a different officer, they cannot frame it as casual conversation. That protection remains fully intact. Use it every time, for every situation, even when you think you don't need it, especially when you think you don't need it. You still have political power. The Supreme Court interprets the Constitution, but Congress and state legislatures write law. Legislators can create a statutory right to sue for Miranda violations, even if the constitutional remedy has been weakened. They can mandate recording of all interrogations, require body cameras, and build independent oversight structures. Every erosion the court allows, a legislature can reverse if enough citizens demand it. Now let me give you 3 concrete steps you can take immediately. Step 1, memorize the invocation formula and repeat it. Do not just say, "I want to remain silent." Say this: I am invoking my right to remain silent under the Fifth Amendment. I am invoking my right to an attorney under the Sixth Amendment. I do not consent to any searches. I will not answer any questions without my lawyer present. Then stop talking entirely. If a new officer enters the room an hour later and starts friendly conversation, wait and then say it again. I am re-invoking my right to remain silent. I want a lawyer. Calm, clear, every time. Step 2, always ask for a lawyer immediately. The moment you say, "I want a lawyer," a legal wall goes up that police cannot cross. They cannot reinitiate contact. They cannot use a different officer. They cannot reframe the conversation as informal. Unlike the right to silence, the right to counsel has not been weakened by recent decisions. It is your strongest protection in any custodial situation. Use it without hesitation, without apology, and without explanation. Step 3, save a lawyer's number right now, not when something goes wrong. Tonight, search for a criminal defense attorney in your state, read a few reviews, pick one, and save the number somewhere you will find it under stress. Then sit down with your household, your partner, your family members, anyone who shares your space, meet them, and make sure they know 2 things. They do not allow law enforcement inside your home without a warrant, no matter how friendly or routine the visit seems, and they have that lawyer's number saved before they ever need it. Here is the truth that no Supreme Court justice will say directly. The trend across these 3 decisions reflects a coherent judicial philosophy. The current court, across its ideological differences, tends to trust police discretion over individual rights. It tends to create clear rules that benefit officers and flexible standards that give citizens uncertain protection. It sees constitutional rights as occasional correctives rather than permanent shields. Justice Gorsuch, concurring in Barnes, wrote that Fourth Amendment jurisprudence has become so riddled with exceptions and special rules that officers cannot reasonably be expected to know what the law requires. His solution was to simplify, but to simplify in ways that benefit officers, not citizens. Justice Sotomayor, in her case concurrence, offered a different warning. The court continues to erode the procedural safeguards that make constitutional rights meaningful. A right without a remedy is no right at all. She is right. And across these 3 decisions, the remedies are disappearing. The Fourth Amendment still exists, but proving excessive force now requires navigating a shapeless totality standard with no guaranteed floor. The Fifth Amendment still exists, but the right to silence requires constant reinvocation, and Miranda warnings cannot be enforced through civil lawsuits. The mechanisms that made these rights real in practice, clear rules, personal accountability, automatic exclusion, have been removed by unanimous decisions that barely registered in the news cycle. Your job as a citizen is to understand what has changed, protect what remains, and demand that your elected representatives restore through legislation what the courts have quietly taken through interpretation. Because the Constitution belongs to all of us, and we do not have to stay silent, unless we are in an interrogation room, in which case silence is exactly what the framers intended, and exactly what 3 unanimous decisions are working hard to take away. Legal scholars have started calling this the Third Amendment problem, a dark joke among constitutional lawyers. The Third Amendment, which protects against quartering soldiers in private homes, has never been the basis of a major Supreme Court case. It sits in the Bill of Rights as a historical artifact with almost no modern relevance. Critics now argue that the Fifth Amendment is being quietly nudged into the same irrelevance, a right that exists on paper, that appears in textbooks, that sounds powerful when recited, but that fails at the precise moment ordinary Americans need it most. Not because it was repealed, not because it was challenged directly, but because its remedies were stripped, its procedures were weakened, and its invocations were made contingent on perfect legal knowledge that most people in a police interrogation room simply do not have. That is the lesson buried inside 3 unanimous decisions. Rights without remedies are just words, and words without the force to back them belong to whoever holds the power in the room. Know your rights, use them precisely, and make sure the people around you know them too.